Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. We have come to our last video of this legal maxim series. I hope you are finding this useful. A consolidated PDF of all the 20 videos have been added in the description below. You can revise all the legal maxims by downloading that PDF. Now coming to the first maxim of this last video, in pleno. This means in full. It is commonly used to describe a situation or an activity that is happening at its peak or in the middle of it. This phrase emphasizes that something is occurring intensely or at its highest point. The next maxim is in omnibus. This means in every aspect. The word omnibus means for all or many. In legal term, the word omnibus is followed by the word law, omnibus law, which means a collection of many cross-sectoral regulations or laws at different levels in a regulatory product. Remember, you have heard this term falsus in uno, falsus in omnibus. False in one thing, false in everything. We have discussed this legal maxim earlier. So here in omnibus, this Latin phrase refers to something that applies to everything or cover all aspects of a situation. The next maxim is in mortua manu. This means in a dead hand. Mort means incapacity of selling possession or estates. The origin of this term indicates that a person who had died years earlier still dictated land use to the next generations by leaving it to the church which never died and hence never had to relinquish land. Usually it is considered in cases of properties which are owned by religious societies. Such properties are said to be held in mortua manu or in mort mean, since the members of such religious corporations were considered civilly dead after taking religious oaths. The next maxim is in loco parentis. This means in place of the parent. This refers to the legal responsibility of a person or organization to take on some of the functions and responsibility of a parent. For example, when minor children are entrusted by parents to a school, the parents delegate to the school certain responsibilities for their children and the school has certain liabilities. In effect, the school and the teachers take some of the responsibility and some of the authority of the parent. The exact extent and nature of this responsibility and power vary from one society to another and from one school system to another. The next maxim is in limine. This means at the outset, on the threshold. A motion in limine is a pre-trial motion asking that certain evidence be found inadmissible and that it not be referred to or offered at trial. Therefore, an in limine motion is a motion before a trial. It is a motion to suppress illegally obtained evidence. The next maxim is in futuro. This means in the future. This term is used to refer to things that will happen in the future. For example, the contract stipulated several obligations that were to be fulfilled in futuro, or the court took into account the in futuro potential damages while making the judgment. Coming to the next maxim, in foro conscientiate. This means in the forum of conscience. It refers to situations which are matter of conscience rather than a matter of law. For example, a person may conceal facts in a transaction in order to make a larger profit, which although may not be required to be disclosed by law, but would be unethical. The next maxim is in delicto. This means at fault. This is a term which is used to refer to two persons or entities who are at equal fault, whether the malfeasance in question is a crime or a tort. In delicto refers to a situation where both parties are equally responsible for a wrongdoing, also known as pari delicto. It is important to note that in delicto is different from ex delicto, which refers to a cause of action arising from a wrongful act. For example, if two people agree to commit a crime together, they are both in delicto. So usually in legal cases, in delicto describes a situation where both parties are at fault and cannot sue each other for damages. The next maxim is in esse. This means in existence. In esse denotes the state of being or existence of something. It is utilized to indicate that something currently exists or is currently in a state of being. The next maxim is in extenso. This means at full length. The term in extenso is used to describe something that is presented completely without any omissions or reductions. When something is set forth in extenso, it means that it is presented in its entirety without any parts being left out. Then the next maxim is in terrorem. This means as a warning or deterrent. In terrorism is a legal threat. Usually one is given in hope of compelling someone to act without resorting to a lawsuit or criminal prosecution. Usually this phrase is used to describe provisions in contracts or wills meant to scare a person into complying with the terms of the agreement. For example, a will might state that an heir will forfeit an inheritance if the heir challenges the validity of the will. Of course, if the will is challenged and found to be invalid, then the clause itself is also invalid and the heir takes whatever he or she would have inherited if there were no will, also called a terrorism clause or a no contest clause. The next maxim is in situ. This means in its place. In legal terminology, in situ refers to something, typically evidence or a legal situation, that exists in its original place or natural setting without having been moved or changed. So here we come to an end of our legal maxim series. I hope you have found this useful. I'll suggest you to go back and revise all the legal maxims. You can download the PDF from the description and you can find all the 20 parts in a single document and revise using that. You can refer to the detailed version or explanation using the videos present on this channel. Wish you all the best for your upcoming exams. If you have any form of queries, you can write them down in the comment below. Thank you so much for watching this video. Subscribe to our channel. Stay tuned.